Okay, so this is just to briefly talk about the assignment one and the next assignment you're going to see. So, grading assignment one took a long time. When you think about it, if I was grading about 2 o'clock last night, and I made this little video to explain some of this to you, and then it went away. So I thought I would just talk to you a little bit about it. Just, it's about 10 hours worth of grading to give about 15 minutes to each one. And that's just, 15 minutes probably isn't even enough. So I want you to all have the opportunity to rewrite that. But I also want you to know that they're graded a little bit on the hard side, and that there's a reason for that. Traditional law school, you go through an entire semester and have one exam at the end, right? You know that. And if you have a bad day, or if you missed an important concept, you're out of luck. You may not have had a class like this. You may be a 2L, and this is the first real elective that you've had. You certainly have never had me as an instructor. So the grades, if you got a low grade or lower than you would like, do not worry about that. Number one, the grades were a little on the low side so that we would have room to improve, okay? Because we are preparing not only for the final in this class, but for the bar exam, because family law is going to be on most of your bar exams. And I'd rather have you work at something and get better at organizing, grammar, supporting, statutory authority than for me to just give you a little bit better of a grade and move on. Because to me, that was the most frustrating thing about law school, is not getting any feedback until it was too late. I didn't have any feedback, didn't do anything twice, and that was really frustrating to me as a student. So I want you to all have that opportunity. Now, several of you got high 90s, and if you don't want, there's not much room to move. If you got, a 90 or above, great job. There's not much to do. However, if you do want to write again and get more feedback, great. What was interesting about those assignments is that I got so many different answers. And that's hard to grade because there's definitely what I feel is the most correct answer. But some of you, and in fact, at least 3 or 4 times I said, I don't agree with this. For instance, I don't think Jamie gets spousal support. But those of you who looked at the law and applied it and supported your answer correctly, I didn't take any points off for that, because at some aspect, at some point, that question was really subjective, and the bar is going to be subjective too. That's another frustration of mine, is that for me, there's a definite answer to that essay question, but for those of you, as I said, who did not agree with me, as long as you could support it fully, you got a good grade. So when I look at where I took points off for the majority of those assignments, and I give you all significant feedback. If you need more, if you have specific questions, please email me. I'm happy to give you feedback. If you need a Zoom meeting with me to understand the feedback, not a problem. The biggest place where people lost points, if you missed something, if you did not talk about spousal support at all, and you did not give me the 2 statutes, because I said specifically in the question you'll have at least 2 statutes, one for spousal support, one for equitable distribution. You missed a lot of points on that. I can't give you points for something you didn't say at all. Several of you mixed up the facts. There were a few of you that mixed up Jamie and Tracy, and there were a few of you who valued things incorrectly, like the credit card debt, if it was $15,000 and I saw you put 10, that's a real simple mistake to fix, but it's a big one. You can't do that. Some of you had problems with organization, although not a whole lot. One of the big areas I saw is not a lot of statutory support. So several of you put down most of you, if not all of you, got the correct statutes. Great. But you didn't apply them. If you said, here's what the statute, here's all the factors for equitable distribution, I think Tracy should get the house. Without saying it's because this factor works in Tracy's favor, or under analysis of these 2 factors, Tracy is the best fit to get the house. You need to look at the law, look at the facts, and apply the facts to the law. And if you did not go through and say, here are the factors, here's how they apply to this situation, that may have hurt you. Because the people who did that, and the people that did that consistently, even if the outcome was different from what I expected, got full credit for that. Because as some of this is subjective, as long as you can support your answer correctly and legally, I can't grade you down for that. There were some grammar errors, and because I'm used to Canvas grading, the editing tool in Blackboard is not, in my opinion, as user-friendly. I wasn't able to give complete criticism on grammar, but if you have questions as to where your grammar could be improved, feel free to ask me. For many of you, it was a situation of, if you had read it over again, you would have seen the tense errors, the past and present, all kinds of things that could have been just a little bit better. And there were several of you that I said the language is a little informal. I mean that from a grammar perspective. I do not need you to sound like a Supreme Court justice, but I do need it to be formal to the point where it reads as if this is a legal document. To that end, several of you approached this as if it were an essay. It was not an essay. You were asked to be the judge and make a decision. So if you approached it writing-wise as an essay, that's something that can be changed. If you did not give me an actual decision and you said, well, it's likely that a judge would, that was not the call of the question. This is a very good tip for bar exams and for any other exams. If the call of the question is you are a judge, make a decision, and you don't actually make a decision, you can't get full credit for that because the question said make a decision. So that means yes or no on spousal support, why, and how much for how long. That is a very discrete decision that you need to make. And if that was something you struggled with, fix it. I have the essays overall, I call it essays, the answers overall were good. They showed that you understand how to find the statutes. They showed that you understand mostly how to apply them. They just could be better for you to get a better final grade. So take this as an opportunity, not an indictment of your legal abilities, because honestly, if they had not been so good, I would be less inclined to give you just a blanket rewrite, because they were all turned in on time, and you did make a very good effort at them. I'm very impressed. So this is just an opportunity for you to improve. The second big thing about the essays is that many of you in Kentucky, and there are similar statutes in other states, looked at the statute on retirement and misread it. So I need to clarify that for you. The Kentucky statute about exempting the IRA or exempting retirement. Many of you looked at it and interpreted that, well, if Jamie doesn't have retirement, then I can't count Tracy's, and that's not what that statute does. What that statute does is this. It says, and go back and read it again because it's a really good exercise in interpreting what a statute says, because it's not always easy. That statute says if one party has a retirement portion that for some reason cannot be considered. I'll tell you that some military pensions, specifically if the marriage was less than 10 years in the military, they can't be split in a certain way to give an ex-spouse a direct payment. There are other types of retirement, let's say retirement from a previous spouse. So let's say I've been married a couple of times and I have a marital interest in a previous retirement. I can't split it again. So while I have that as an asset, it can't be counted in the marital estate, okay? So if for whatever reason, wife has a retirement that cannot be split, then the corresponding amount for husband will not be considered marital property. It's a way of keeping it separate and equal. So if wife has a $50,000 retirement account that cannot be split maritally, then the first $50,000 of husband's retirement will not be marital property. It's a way of evening it. Good call on finding it, but it doesn't apply to this situation because Tracy's IRA absolutely is marital property and absolutely can be split with a qualified domestic relations order. Also, for those of you who made assumptions about the fact pattern because there were issues that facts that you needed that you didn't have, great. As long as you make those clearly and reasonably. There were a few of you that made a kind of unreasonable assumptions, and I pointed those out. But The assumption with Tracy's IRA, we don't know how much of it is marital, because some of you had pointed out, well, if it was created beforehand, the portion that accrued before the marriage is non-marital under Kentucky law. I think everybody had an equitable distribution state. I don't think we had any true community property states. Then we only separate that portion which is marital, and that's absolutely correct. The other big misconception is that there were a few of you that gave Jamie more. Jamie does not get more under any theory, because she or he, and again, these were gender non-specific terms, so go back and look at your answer, and several of you made Jamie female for some reason, and I don't know why. So take a look at that. I didn't count off for it, but they were gender non-specific for a reason, so that you didn't associate one with femaleness and homemaking and one without, but some of you did that, so take a look at that. But the assumption is that because Jamie earned more, she gets more, and that isn't the case, because Jamie is not disabled. We didn't see that in the fact pattern. Jamie was certainly not taking care of kids. We did see that specifically in the pattern. So because Jamie did not contribute as much, Jamie does not take as much out. And so take a look at that with your answer. But I wanted to clear that up about that retirement statute and make sure that that was clear. And that if there is an unequal non-50-50 split, that the more of the estate goes to the person who contributed more. And that some of you went so far as to give Tracy, the higher earner, all of the estate, and it's not going to be 100 split. It's not even probably going to be as much as 80-20. Courts tend to gravitate toward 50-50, but go 60-40, 70-30 in situations like this if we have the assumption that Jamie is voluntarily underemployed, is the phrase that I used to describe Jamie. So overall, you did a great job with this. I do not want you to worry about rewriting them now. You are going to rewrite them. I set aside 2 weeks for civil procedure, and we will not need 2 full weeks. So there's 1 week where we'll write a petition, write an answer. In the second week, I can't remember if it's second or first, the other of those 2 weeks, you will work on the rewrite for that assignment. Right now, work on the child support guidelines. This is a much more straightforward assignment with less analysis. I want a guideline calculation and an explanation of how you came, why you put in what you put in for the guidelines. And that is it. We are rounding the corner. We're getting past the halfway point. You guys are doing really well. Keep up the good work. And again, email me if you have any questions.